eliminated any defense that Mr. Brewer had. And what I mean by that is the state's position was that Mr. Brewer was the aggressor, that Mr. Brewer provoked the matter, and that Mr.
Well, Mr. Brewer or Mr. Hughes?
No, the state's position was
Oh,
that
okay, I'm sorry.
Mr. Brewer was the aggressor, Mr. Brewer
Yep.
provoked the matter, and Mr. Brewer committed an aggravated assault. Well, in the abstract, the jury was never told under the non-deadly force that Mr. Brewer had the right under the statute to, when there's someone wrongfully interfering with his property, either in a criminal or a civil way, he had the right to approach him. He had the right to use non-deadly force if he believed that to be reasonable. And the jury had no idea what that was. So essentially, the jury was left with that Mr. Brewer approached him, had a gun, and had no way in which to evaluate the statute, both the stand your ground statute and the jury charge with regard to non-deadly force. And that the court, in cases including the most recent Espichan, E-S-P-I-C-H-A-N versus State, indicates that the court should give the instruction even if the court believes the defense is flimsy or there's not sufficient evidence that is, no matter how weak or flimsy the evidence might be. And so it was our position at the time of the instruction and today that the jury should have been instructed that Mr. Brewer had the right to use non-deadly force to approach Mr. Hughes, who was at that point interfering with his property, and it was for the jury to determine whether or not his conduct was reasonable. Without that, the jury's left with that Mr. Brewer had an obligation to retreat. The jury could have concluded that Mr. Brewer had a right to be there if Mr. Brewer had the right to be there, and if Mr. Brewer was using non-deadly force at that particular point in time. The first two items, when he approaches showing the gun, and then when he points the gun, which we submitted as non-deadly force, that those actions were justified. At that point, he was entitled to be there, and he would not have an obligation to retreat before using deadly force. As it currently stands, the jury's left with Mr. Brewer had an obligation to retreat, and we all know from the surveillance video he didn't retreat. So it was a fait accompli what the verdict was going to be. And as I indicated in the moving papers, I suggest to the court that he should have been charged on that, even if the court believed it to be weak or flimsy, so that the jury could have evaluated it and they could have made the decision, because it was the jury that was ultimately obligated to make that decision.
Thank you. State wish to be heard?
So just briefly, I'm going to once again quote the case I quoted during the trial, which is Miller v. State, 613 Southern 2nd 530. And again, the conduct that the defendant was charged with was discharging the firearm and causing the death of Garrett Hughes. That conduct is deadly force. So the jury instruction, according to Miller, that would be appropriate for the use of deadly force would be a self-defense instruction about the proper use or application of deadly force. The defense is trying to separate this conduct into two events, the patrolling of the parking lot and then the shooting. And it's not that clean. Drawing that gun on Garrett Hughes, first of all, the defense is arguing he had the right to defend his property, his parking lot. From what, Judge? Defended from what? It's a public parking lot. Garrett Hughes had the right to be there. He was urinating on a building next to the parking lot that the defendant didn't own. What was he protecting the parking lot from? Urine from the building that may have trickled over? I mean, this is absurd. So there was nothing to defend the parking lot from because there was no threat on that parking lot. Mr. Brewer cannot walk around that parking lot all day long, every day, wielding a firearm at people, which is what the defense would have you think. Well, he's allowed, it's not deadly force, it's not deadly force. He can just walk around and wield a gun. That is not the law. Once he drew that gun on Garrett Hughes, then it becomes, the event is, it's all intertwined. The event had begun where deadly force culminated. That's exactly what happened in Miller, where the defendant testified that he did not mean to fire the gun and that he didn't point his gun at the complainant. he fired a warning shot in the air. And the court said that the fact that he fired the warning shot in the air was ultimately the use of deadly force, just like the fact that Lloyd Brewer pulled the trigger ultimately was the use of deadly force. And as such, the appropriate jury instruction would be a deadly force instruction, not a non-deadly force instruction.
Thank you.
Your Honor, there were other arguments in their motion. Is the defense abandoning those? If not, I'd like to put our position on the record.
Well, I
Number
didn't
8
think they were abandoning any arguments. I was under the impression that, as counsel said, the motion spoke for itself and didn't want to elaborate on other grounds, is what I understood your position to be.
Yes, Your Honor, I think that on the other it was just on the papers.
Yeah, but if you want to say something quickly.
Yes, Your Honor, just for the clarification of the record. Section 8, they've raised the argument that Officer Lopez's direct examination was limited under a mistaken belief that it was previously ordered by the court. I just want the record to be clear that at all times, we had a video exchange with the defense. The defense knew exactly what the state was going to submit. We informed them. They asked for it to be redacted. We redacted. Everything was stipulated to. It was entered into evidence at the start of the trial. At no point in time during the testimony of any of the witnesses did the defense ask for more parts to be played. At no time did they object to anything being played. So when we proceeded with the witness, and the witness was cautioned not to talk about anything that was not played because it would be inflammatory, it could be prejudicial, for the defense to then ask a question about is that everything that was been said, that's what the state objected to. They have not proffered what they were hoping to elicit from this witness for us to find that this was abuse of discretion or error. And secondly, the defense could have recalled the officer and had him testify to any other parts of the video that they requested, and they didn't. The last argument that they have in their motion is the fact that the court did not allow the defense to establish reputation evidence. Well, Judge, as I stated in the middle of the trial, we had a hearing. You ruled back on September 20th, 2024, in which you made it very clear how reputation evidence could be established. You explained in the order how it could be established. The defense failed to do so, and I think the court was proper in which, when you struck any testimony that they were trying to gather from the witnesses as to Carson's reputation, or as to Garrett's reputation.
Thank you. So, Mr. Brewer, I certainly respect you and your attorney's right to seek a new trial. I respect the fact that you all may disagree with some of the decisions the court had made during the course of the trial, some of which were embodied, all of which, or the majority of which were embodied in the motion for new trial. We've heard argument on one of the main issues that defense has raised. We've heard response from the state. I respect the fact that you have that right. I feel comfortable that you received a fair trial. I feel comfortable that I made lawful, legal, appropriate rulings, including the issue of not giving the use of non-deadly force. I don't believe it was raised by the evidence, nor was it called for or appropriate. But again, people can disagree with that, and certainly this matter will be reviewed by higher authority, and that's one of the issues that's been preserved. But from my standpoint, the rulings were correct, and I'm going to respectfully deny the motion for new trial. So with that, the next question is, has the defense seen the pre-sentence investigation?
Yes, Your Honor, we have.
State seen the pre-sentence investigation?
Yes, Your Honor.
Is there any objection to the contents thereof? No. No? State of any objections?
No, Your Honor.
So we have a score sheet here. It's kind of a moot point with this charge, but nevertheless, here it is. Has the defense seen the punishment code score sheet?
Yes, Your Honor, we've seen the score sheet along with the pre-sentence report, and we've read the law also, Judge, and we know what discretion Your So,
So you don't object to the score sheet? All right, thank you. So, were there any matters that counsel for defense would like to argue, or to statements to be made, or evidence to be introduced?
no, Judge, I would like to be heard briefly before you impose sentence.
Well, this is the time. I mean, basically, the format I use, we hear from defense, then we hear from the state, with any, including any victim impact matters, then we give Mr. Brewer an opportunity to make a statement, and then I speak, pronounce, so to speak, so.
Your Honor, it's been a very difficult situation.